for coming today. I'm giving a presentation on a case I was involved in where Justice Feasby established the tort of harassment in Alberta. And I'm going to go through it a little bit. It's the first time in Canada that this tort was recognized in this manner and a test was articulated. So I'll go through that. And then I want to, at the end, touch on some of the judicial treatment of this decision since Justice Feasby's decision was issued. I understand if you have questions throughout, you can put them in the chat, and Catherine will organize them, and I can respond to them at the end of the discussion. Briefly, by way of introduction, I am a partner at Field Law in Edmonton. I'm called in the Yukon, Northwest Territories, BC, and Alberta. I am primarily focused on health law and hospital physician relationships. I am the health law group practice group leader at Field Law, and we have a team that focuses exclusively in this area. I'm going to give a brief objectives today, a brief overview of the Johnston decision, the identified gap in tort law, the test that was articulated by Justice Feasby, and as I said, some of the judicial treatment afterwards, and there was some secondary commentary as well. So the respondent Johnston may have not made its way up to the Yukon. Kevin J. Johnston was a podcaster and a self-proclaimed journalist. He was a resident at Calgary, and he hosted talk shows and streamed videos on various social media platforms, Facebook, Instagram, YouTube. And at the time, he was a mayoral candidate for Calgary. And in doing so, this was during COVID. And he was a self-appointed spokesperson for Albertans opposed to the efforts and public health efforts of the Chief Medical Officer of Health in Alberta here in AHS. And these efforts were intended to lessen the spread of COVID-19 in the province, protect Albertans from illness and death from contracting COVID, and reduce pressures that COVID was having on the Alberta healthcare system at the time. Interesting, a lot of my practice during COVID blew up because of some of the challenges that public health inspectors were facing in enforcing medical officer of health orders, including orders limiting with social distancing and businesses. So I was very actively involved in enforcing orders, obtaining King's Bench orders, and dealing with contempt applications. And that's what I ended up doing with Mr. Johnston, who was a prolific poster, but also attended a lot of these rallies and harassed and attempted to preclude public health inspectors from doing their job. In the course of this, and I'll get into some of the strategies involved in proceeding against Mr. Johnston, but we were seeking, in essence, injunctive relief against him to preclude him from engaging in certain activities. And I initially brought an application seeking this relief, but part of that was an undertaking to file a statement of claim as well. I brought the application in front of Justice Germain in Alberta, who's since retired. Justice Germain, the application had a lot of social media clips, video clips. Unfortunately, for my paralegal, she had to spend a lot of time listening to some of his rhetoric, downloading these clips, which were put before and played before the court in our application. And there was hundreds of these clips. He was very bombastic in his social media presence because he was using this also as a platform to run for mayor of Calgary. Collateral effect, I also ended up being the target of the harassment, but can't be both counsel and plaintiff in an action at the same time. And I ended up, he doxed me, doxed my parents, threatened to attend at my house with a bunch of people. He ended up getting my address, posted my Google Maps of my house, but none of that came to fruition. It ended up just being threats at the time. So this is the first appearance in front of Justice Germain, and a quote from that decision: the evidence supporting the breach of the second Rook order, that was a Rook of, at the time, Associate Chief Justice Rook, which was enforcing the Chief Medical Officer of Health order, consists mainly of venomous, hateful, and threatening rants about various AHS personnel entrained into Mr. Johnston's various social media sites. These were introduced as exhibits through affidavit. Watching Mr. Johnston on these videos played in open court and attached as electronic exhibits to the material filed by AHS reveals an individual who is frightening in his bombast and demeanor. His words could only inflict fear and concern for the personal safety in AHS personnel who Mr. Johnston targeted. They were overtly harassing in their nature. He presents as a dangerous, out of control individual. The malice that Mr. Johnston expresses is simply beyond the pale of normal social discourse. Reasonable people can reasonably disagree with public health orders, but in Mr. Johnston's case, whether for economic or political gain, he clearly reflects an animus to HS personnel that is shocking. So that was the initial decision with respect to some of the injunction, at the time, an interim injunction that I was seeking. The goal was at the end to have a permanent injunction, but doing so, we had to follow through with the claim. Now, I can tell you that after we got the order, the injunction order on an interim basis, Mr. Johnston was immediately in breach of it. So we had a ladder of escalation of contempt orders, starting with fines and including imprisonment, which we'll talk a little bit about. The facts deemed admitted against respondent Johnston in the claim, this is in the civil action, making harassing and defamatory remarks, included calling one of the public health inspectors a Nazi, terrorist, criminal, threatening to attend at her house, claiming that our criminals have committed culpable homicide, criminal harassment, extortion, intimidation, that applicants are terrorists and have engaged in acts of terrorism. Applicants are Nazis, Gestapo, fascists, communists. And there was two public health inspectors I was focusing on as individual plaintiffs in the action, and AHS was also a plaintiff in its capacity as a health authority. Again, piece of dirt, scum. He data mined her online social presence, so I'd pulled photos of her, her husband, her kids from Facebook, and then he would post them with Nazi symbols and calling her an alcoholic, a bunch of things that were defamatory, but also harassing. So we filed a statement of claim. Mr. Johnston didn't defend, and we ended up with a default judgment. And we noted it in default, and proceeded with a default judgment. The primary objectives were to establish that there was defamation and quantification of damages for that. But we also really were focused on this permanent injunction, not only to enjoin him from the defamatory comments going forward, but more importantly, the harassment. And we'll get into why that caused me some concern. I mean, there's a good body of case law, obviously, on defamation and enjoining that conduct, but harassment was something different in this context. And how do we enjoin someone from engaging in further harassment? So that establishing that tort, in my mind, was a key to getting that injunctive relief that we were looking for, that specific nature of injunctive relief. And this is from the statement of claim that we filed. And this is paragraph 38. This really focuses on the harassment aspect of it as opposed to the defamatory claim. So we wanted to preclude him from posting personal identifying photographs or videos of HS plaintiffs, along, with graphics including swastikas, demeaning comments. Some of this captured by defamation, but some of it not. public identifying or attempting to identify employees, finding their houses, doxing them, posting their houses, threatening to send people over, attending at public rallies, public events that are in breach of the CMOH order in order to harass the public health inspectors, shouting, mocking, aggressively videotaping, um, and getting into their personal space. So some of this could be addressed by defamation, but some of it not because of the nature of the harassment, which we argued was tortious. Now, the seed had been planted on pursuing the tort of harassment in another case I was involved in. It was a physician case. Dr. Algamdi was an orthopedic surgeon in Alberta. He had his privileges removed from AHS and commenced upwards of 16 pieces of litigation as self-represented. Dr. Algamdi, in fact, went back to, during a period of suspension, went to law school, got his law degree, and got called in BC. So he was acting as a self-rep, but also as an officer of the court and a lawyer. In Algamdi, one of the issues that was raised, Justice Goss at the time, we ended up having the matter struck. I won't get into Algamdi because that'll take the rest of today, but Justice Goss looked at some elements of the tort of harassment, and at the time it was kind of musing about the theoretical case of tort of harassment, what might be part of it. And this had been going on across Canada. It wasn't new, but Justice Goss kind of crystallized it in Algamdi when looking at that. But the very week I was looking at filing the statement of claim, Justice Ingalls in Alberta came out with a case where she explored again the tort of harassment in the context of online revenge porn. And this is the Shillington decision that I have here. And it was really timely. I was literally reading Canley at the time, reading this decision of Justice Ingalls, and thought maybe this is a path forward on this tort in this instance. So the seed had been planted. We drafted the pleadings specifically to advance this claim to seek the injunctive relief that we wanted. One other case I had relied on quite a bit during the COVID pandemic was this Muslim Council of Calgary versus Mora decision. And this was a case where the court had basically found that harassment was a judiciable issue that the courts could intervene with their inherent jurisdiction. And it was a case, either through restraining orders or some sort of injunctive relief could enjoin conduct, harassing conduct. So I'd use this case to seek protection for people that were subject of harassment. But I also used it to argue that there was a gap in the law with respect to whether or not this was tortious conduct. And that case was referred to Justice Feasby in our application for default judgment seeking this permanent injunction. And he referred to it at paragraph 19. He said the fact that this court regularly grants restraining orders to address harassment indicates that harassment is a judiciable issue. Recognition that the wrong that is being restrained in these cases is tortious harassment is an incremental change in the law. So he recognized that, this was a new area. The recognition of the tort of harassment in turn allows damages to be awarded in circumstances where the court now can only issue restraining orders. Arming the court to redress the problem of harassment by adding the power to award damages in appropriate cases is long overdue. It was an interesting application. It was in Calgary, a full day special in Calgary. Mr. Johnston attended as virtually as a self-rep. Interestingly, and a bit of an aside, Mr. Johnston, so I had said that he was in contempt of the initial interim injunction order enjoining him from engaging in harassing conduct. We started with fines and it escalated to a term of incarceration. I think it was 30 days served intermittently. Interestingly, when we got the order for incarceration. That was Justice Germain that actually issued that. Counsel from Ontario's attended an application because he was also in contempt of an order in Ontario where they had received a 3-month incarceration period. So they were queuing up to, when Mr. Johnston was finished his term of incarceration in Alberta, to have Corrections Alberta transport him to Ontario to serve his term there. And near the end of the 30-day term, again, it may not have made the news in Yukon, but Mr. Johnston made a run for the border and was arrested in, I think it was either North Dakota or Montana. He illegally crossed into the States. So on one weekend, I get a call that they've arrested, I think it was Homeland Security had arrested Mr. Johnston, who almost froze to death because he wasn't properly clothed, and crossed the border in some wooded area and said, "We have Mr. Johnston." And my initial response is maybe they could keep him, but he was brought back to Alberta to finish his sentence here. But so we argued that there was a gap in the tort law, and we could only get so far with a defamation claim, and the persistent and harmful conduct of Mr. Johnston didn't fit neatly within defamation or any other tort that would provide us with the remedy we wanted and the injunctive relief we wanted with respect to the public health inspectors. In this argument with Justice Feasby, Justice Feasby and I spent a long time during that special arguing back and forth, not arguing, but musing back and forth. It was really a dialogue with respect to this tort. We referred to secondary sources, including this Dan Priel article, Paths for Tort of Liability for Harassment, which was in the Ottawa Law Review. In his decision, Justice Feasby agreed with our argument and defined the tort of harassment as follows, and this is at paragraph 107 of his decision. A defendant has committed the tort of harassment where he has, and this is the 4-part test, engaged in repeated communications, threats, insults, stalking, or other harassing behavior in person or through other means, that he knew or ought to have known that this was unwelcome, which impugn the dignity of the plaintiff, would cause a reasonable person to fear for her safety or the safety of her loved ones, or foreseeably cause emotional distress, and in fact did cause harm. So he articulated this 4-part test, in part importing some of the musings that I talked about earlier out of Ontario from Justice Goss, from Justice Ingalls. The court had been musing about, is this tort available? And if so, what it might look like. Justice Feasby finally said, in this case, in these circumstances, it is available, and this is how it would look like. So immediately after the decision was issued, I got lots of calls from labor and employment lawyers, including from my own firm, because the nature of harassment was never seen as an actionable issue in this context. So there was a lot of interest. There was a Canley case comment published on it. I did speak at Canadian Bar Association in BC Labor and Employment section on this issue and on this case. And there was this case comment by Thornycroft, which was interesting, where he welcomed this new tort of harassment. He reconceptualized it a little bit. He thought other elements may be required, as often you see with new courts and new case law. People are looking at it, testing it, debating it. One thing that was unfortunate, it would have been nice to have appellate authority on this decision in Alberta. I think Justice Feasby wrote a really good decision. He is excellent justice, and he's always very thoughtful in his decisions. But we didn't have the benefit of appellate review because while Mr. Johnston did file an appeal, he abandoned it. My understanding is he now resides somewhere in Costa Rica or somewhere outside the jurisdiction. So it was abandoned and not appealed. And we were tracking the appeal because it was interesting. UBC Law School was mooting this case, and they kept reaching out to me wondering, we want to moot it, but we don't want to get out ahead if there's an appeal. So I was keeping them, one of the professors there, updated on the status of this appeal so that their students weren't mooting something that was going to get some appellate commentary. So I'm going to talk a little bit about post Johnston treatment. It has been cited quite a bit since in Alberta, BC, and Ontario primarily. And there's been some refinements. BC has not adopted it fully. The initial decision was the Sandar Fruit Packers and Macaskill case, where Justice Branch accepted that, and this was in the context, I think, of a summary judgment application. There was an argument for recognizing the tort of harassment in BC. He found it wasn't properly pled. So on that basis, I think the claim had been struck, and there was no serious issue to be tried. He declined to hear the harassment-based injunction, and the court observed that they couldn't invoke Justice Feasby's broader test, and they brought in BC a higher threshold from the mainland decision. So mainland basically looked at this, and whereas I'm just going to scroll back a little bit to the test, Justice Feasby required the causal element of causing harm, and mainland imported basically a higher threshold in BC. It couldn't just be causing harm, but it had to be severe or extreme emotional distress as harm. So it elevated the threshold of the availability of the tort. So harm wasn't just something that then could be assessed, like most torts, in a compensatory way, like how much is it worth? It was, they said, an element of the test is this severe or extreme emotional distress. So even to meet the test of the tort of harassment, you had to have this escalated harm that was required. Post Stander, there was a solemn decision and versus Owen Wiggs law firm in Vancouver. It was a bit harsher and solemn. They said the courts have not adopted the tort, and on that basis alone, it was struck. And then the Besler decision, which is the most recent one, came out, and Justice Hardwick, in essence, found that, listen, I'm not going to follow solemn because that's basically that the tort's not available in BC, because, but in fact, preferred Sanders saying, well, the tort's available. It wasn't available to the plaintiffs in that case because they didn't meet the test, which was that escalated damages claim of severe extreme emotional distress hadn't been met. And because of that, there was a factual deficiency in the pleadings and the claim couldn't proceed. So that has been how it's been treated in BC. It is technically available as a tort, and BC is willing to entertain it, just at a higher the test as a higher threshold. So we're still waiting to see for a case that crosses the finish line on establishing the test there. Ontario, as there's been some jurisprudence treating it, it hasn't yet been established in the DS versus H Police Services Board case. They found that the communications were sporadically relatively mild, so it didn't meet that high threshold required of harassment, and it was dismissed on that basis. Johnston was cited in the estate of Shantha Kumar and Royal Bank of Canada. And again, they didn't find that the tort existed because the test had not been met. So the courts have been very cautious, making sure the test is met, and sometimes, as in BC, we saw in BC, refining the test so it makes the tort less available in a certain sense. So yeah, as we see now, while it's available in practice, it really takes a specific set of circumstances, and probably, I mean, I suspect the Johnston case, even if you apply the test in BC, would still still have met that threshold. Um, I think the courts are just saying, yeah, okay, it may be available, but it's going to be available in a limited sense. So that's what we've seen with the jurisprudence post Johnston so far. So that is, I'm happy to respond to any questions. That is the case. Uh, I just got a text from one of my colleagues here that Mr. Johnston apparently is practicing or claiming to practice tax law now as a, I wouldn't recommend getting your tax advice from Mr. Johnston, but to each their own. Um, uh, Happy to respond to any questions, Catherine.
So we did get a question earlier. I'm curious about your comment that the AHS was a named plaintiff. Was that in relation to the defamation action only, or did they have status to claim harassment?
So yeah, good question. So we did name them. Justice Feasby actually dismissed uh, the defamation piece, saying that AHS could not advance a claim in defamation as a health authority, and that we needed these individual defendants to do that. Um, but he also said that AHS, because a lot of individual plaintiffs don't have the means or the ability or the resources to advance these types of claims that protect their employees, he said it was appropriate for AHS to bring the action on their behalf and seek the harassment claim. So with respect to the injunction we received, it did apply more broadly to AHS employees, which was what we were hoping for. It just didn't say you can't harass this one person or this one person. So um, the outcome was beneficial, and Justice Feasby did recognize the appropriateness of AHS as the plaintiff supporting its staff and seeking this broader based injunctive relief. Any other questions?
Just give people a moment to type
Sure.
if they're thinking through things.
It'll be interesting to see. I mean, I suspect, um, at some point we're going to see the jurisprudence evolve more and perhaps with some appellate authority on it that will further refine the test. I've had some calls from other counsel from other jurisdictions just wanting to pick my brain on their claims and always happy to chat with other counsel. But I haven't seen any other than the ones we've cited with respect to that.
Okay, we've got some questions coming in. Do you expect that this tort will be recognized in harassment of civil servants in a regulatory context?
Yeah, it's interesting. I haven't seen it reflected in administrative proceeding or regulatory proceedings. I suspect it would be um, have to be a collateral claim like most torts that you see sometimes where they pursue, regulatory administrative remedies. And then there's a potential of torts following that. Um, we are watching with some interest about how it's been seen. Oftentimes in that context, we see them framed as, for instance, respectful workplace policy breaches and perhaps proceeding under um, that area. I guess they could take some direction from the jurisprudence with respect to the availability of a tort, but I haven't seen it yet in the regulatory context.
And another question, in terms of the Alberta test, does the conduct constituting harassment have to be repeated? Is single occurrence not enough?
Yeah, so you'll see the first part of the test, it is repeated. So the persistence was a big aspect of it. Um, I had also, I believe, had sent cease and desist letters, and then we had gotten the interim contempt or interim orders injunction, which he was in contempt of. I think that that post interim order conduct helped our case because despite court orders, despite cease and desist letters, the conduct persisted. And I think, um, that ends up being a strong element in your case, as Feasby found, engaged in repeated communications, threats, insults, stalking, or other harassing behavior. So I do think that's a required component of it. It's not a one-off. And I think the more you have, the better it is. And as I said in BC with the mainland decision, you have to also show the severe or extreme emotional distress. I mean, one thing you have to do also with any tort in quantifying it, you have to show the effect on the individual. So what we had was our public health officers saying, they had to buy home security. They had to change their patterns, taking their kids to school, the impact and the stress it had on their lives, on their marriages, um, to basically show the compensatory damages for the tort as well. That
Okay.
said, I mean, the judgment was hollow in the sense of we never collected on I think it was on the damages that were awarded. Really, what we wanted was this permanent injunction. We knew we would probably never get the damages, but
Okay, yeah, that answers another question about were any of the damages awarded against Johnston recovered.
no, unfortunately not. Uh, I've had some other luck with it with damages, but in this case, yeah, it was a hollow judgment. Really, we were looking for that permanent injunction, and we knew the likelihood of getting. He had owed so much money to so many people for contempt orders, including Ontario and Alberta, that yeah, we knew the likelihood would be low of recovery. Sorry.
As a person who typically defends claims, what is the threshold for pleadings of the tort that will survive an application to strike? Worried about the floodgates analysis, and I note you acted for a public body which could be subject to such claims.
Yeah, I mean, that's a good question. As we saw in BC, those claims I think were mostly struck on a preliminary basis or interlocutory basis because it didn't meet the threshold. And I think with the mainland decision, BC kind of upped the ante on the threshold for pleadings and claims, that you've got to show not only the test that Justice Feasby articulated, repeated communications, knew or ought to have known as unwelcome. I mean, part of that is being obviously, the cease and desist and being told it was unwelcome helped. Um, and the harm aspect, the mainland decision in BC increased that harm aspect of it. So you've really got to frame your pleadings in a way that you tick all the boxes on a pretty high threshold of facts pled. So we saw cases dismissed where the harm didn't meet the severe extreme emotional distress. We saw cases where communications were sporadic and relatively mild that didn't meet the threshold. So the courts are being very cautious on this threshold issue. You've got to check all those boxes before it'll even get over the hurdle of a summary judgment claim. So um, it's really so far Johnston was beyond the pale. So um, you know, and hopefully that doesn't happen too often. But um, as it stands now, that's really the only case so far in the jurisprudence that checked all those boxes. So I see the apology one there.
Yes, do you think an apology can also be sought as relief?
Yeah, I think like in a defamation claim, you know, post conduct, like um, an apology could probably be a mitigating factor for damages and factored in, might decrease damages, just like, fighting it, maintaining that, um, could be aggravating factor on damages. So um, you can seek it as relief. To be frank, I don't know if an apology um, that the court says you have to provide as a relief would give much comfort to the plaintiffs in this case. I mean, they didn't want an apology from Mr. Johnston, and I don't think it wasn't something we sought. I mean, we wanted him to quit doing it, and that was really the thrust of our claims. So,
Is there any room to add other defendants, such as service providers, for the media posts?
yeah, that's interesting. And that's a complicated question. So we did, when we were looking at enforcing the injunction, we did try to approach at the time Twitter, now X, Facebook, and some of the other platforms, the social media platforms, to remove it, provided the court orders. It was a very delayed response from the platforms. We did have a suspension of a Twitter account, um, but adding them as um, you know, a defendant in a tort of harassment, I don't see a path forward there unless somehow there's some high-handed conduct or they actually engage themselves. But that is an interesting area and an interesting question. I mean, again, I was so focused on stopping it. I did approach the platforms to help in that regard and provided them with the orders. But I have to say it was with kind of mixed results. Just getting who to contact, uh, who actually can shut down Facebook site and things like that was very difficult.
What do you recommend employers do to mitigate potential tort liability with bullying and harassment claims?
Yeah, and I mean this could be the same. And the question that Deborah asked with these platforms is, um, as usual, you maintain a respectful workplace, um, policy that precludes or uh, does not sanction these types of behaviors, and then enforces or implements, the policies and the consequences of the policies in a reasonable way. I think that would probably limit the liability of an employer if they're not complicit in engaging in this conduct. In essence, then your defense would be, listen, we had a reasonable policy in place that denounced this type of conduct. When it was brought to our attention, we took the appropriate steps under the policy to engage the conduct. I think on that basis, you could reasonably defend any allegation that of vicarious liability or liability for the conduct. Conversely, if you don't have that and you don't take the steps, I think employers could be opened up. One question that you have to think of too is when could this become a workplace injury, and if so, would it fall in some sort of no fault scheme, depending on the nature of the injury and what caused it? Something I hadn't really thought of, but may arise in the employer-employee context. Yeah, and Deborah, that's a good point. That I mean, suing or bringing in the platforms would bring in some deeper pockets. Uh, and as I said, we weren't really focused on the money here. We really wanted to stop the conduct. But I agree with you. If there was an avenue to pursue them, that would be perhaps a good reason to do that. I think that's it.
Well, I will remind everyone, well, thank you for coming to see this presentation, and it will all be available on our website afterwards, as well as the PowerPoint presentation with all of the notes. And just
If
giving
anyone
another
has
30
question,
seconds.
sure. And you can reach out to me. You have my contact on the website. Uh, I'm at Field Law. I'm happy to respond to any questions. So this isn't your last opportunity to reach out to me.